You'd think after 30 years of practicing law, I'd seen every flavor of stupid that humanity could cook up. But then I met Beverly Vance, the self-declared queen of the HOA, and let me tell you, she was like a 5-course meal of entitlement, seasoned with delusion and served hot with a side of lawsuit threats. I retired 5 years ago, bought myself a 60-acre ranch out in the country. Peace, quiet, and nothing but the sound of horses, wind, and the occasional moo. I'd earned that peace. My property was clearly fenced, marked private land, and sat outside the HOA's jurisdiction. But Beverly, who lived across the road in the Cedar Ridge HOA, believed everything within a 10-mile radius was somehow under her divine control. The trouble started one Saturday morning. I was fixing a fence post when I saw Beverly marching down the road in a pink tracksuit, sunglasses bigger than her ego, and a clipboard clutched like a weapon. She looked like she was on a mission from God. If God was obsessed with lawn heights and paint shades, she waved at me. "Excuse me, you can't keep that fence that high." I wiped my hands on my jeans. "Morning to you too, ma'am. This fence is on my land, my ranch, my rules." She frowned. "The Cedar Ridge HOA guidelines say perimeter fences must be uniform and natural-toned." I pointed to my bright red wooden posts. "Yeah, I like mine to match the barn." Her jaw dropped. That's a Cedar Ridge HOA violation?" I laughed. "Ma'am, this land isn't in your HOA. You have no authority here." She scribbled something on her clipboard like she was writing divine punishment. "Oh, we'll see about that." 2 days later, I got a letter. Official looking with the Cedar Ridge HOA letterhead. Notice of violation. Unauthorized structure, non-approved color scheme, and restricted access to community members. Restricted access. I nearly spat out my coffee. Apparently, Beverly claimed my private dirt road should remain open for Cedar Ridge HOA pedestrian traffic because, and I quote, "it offers a scenic view beneficial to community wellness." She wanted me to open my private ranch to her power walking club, so I did what any reasonable retired attorney would do. I mailed back a letter short, sweet, and legally airtight. Dear Mrs. Vance, your HOA's jurisdiction ends at the Cedar Ridge sign. My ranch is private land, as recorded in the county registry. Parcel number 1176. Step foot on it again, and you'll be trespassing. Regards, Arthur Sterling, Esquire. Simple, right? But Beverly doesn't do simple. A week later, I caught her on camera, standing at my gate, with 3 other Cedar Ridge HOA board members waving bolt cutters. She was literally trying to cut her way into my property. I stepped out onto the porch and said, "Beverly, you touch that lock, and I'll call the sheriff." She turned absolutely unfazed. "You can't block public access." I raised an eyebrow. "Public access. This is my ranch. Bought and paid for. You're trespassing." She puffed up her chest like a rooster. The Cedar Ridge HOA voted that this land is part of the community greenbelt. I laughed. "You can't vote someone else's property into your HOA, Beverly." Sure enough, 2 days later, a lawsuit arrived, filed by Beverly. Personally. Claim obstruction of public access, non-compliance with HOA bylaws, and emotional distress. She wanted $50,000 in damages. I almost framed the papers. Court day came. Small county courtroom, creaky benches, a board bailiff, and Beverly, dressed like she was about to host a real estate seminar, strutted up to the podium with a binder thicker than a Bible. When the judge asked who was representing me, I stood up. "Your Honor, I'm representing myself." Beverly smirked. "He's a rancher, Your Honor." "I doubt he understands the law," I smiled. "Actually, Your Honor, Arthur Sterling, retired attorney, 30 years in property and land use law." Her smirk evaporated faster than a snowflake in July. The judge looked at her over his glasses. "Mrs. Vance, please explain your claim." Beverly flipped open her binder, hands shaking slightly. The defendant unlawfully erected barriers restricting community members' right to access scenic property. Our HOA unanimously agreed. This land should be open to the public. The judge blinked. "Mrs. Vance, this property isn't part of your HOA," she sputtered. "But it should be. It's adjacent to our development." "Adjacency," I said politely, "does not equal ownership." The judge nodded. "Correct. That's like me claiming Walmart because I parked next to it." The courtroom chuckled. Beverly turned red. But, he mocked me. He's been hostile. I calmly produced my evidence. Maps, deeds, boundary surveys, and video footage of her trying to cut my gate. The judge stared at the screen for a long, silent moment. Then he sighed. "Mrs. Vance, this is open and shut trespassing. I'm dismissing your case with prejudice. Mr. Sterling, you're free to file counterclaims." Beverly's jaw dropped. And the judge added, "I suggest you and your HOA review the limits of your authority before you end up." Back in my courtroom, I did file a counterclaim for property damage, trespassing, and harassment. $15,000. Beverly had to pay it out of her own pocket after the HOA refused to cover her. She resigned from the board 2 weeks later to focus on her mental health. Now, the only time she walks past my ranch, she keeps her eyes straight ahead and her mouth shut. And every time I see her, I tip my hat and smile. Morning, Beverly. Scenic enough for you. Subscribe to HO Conflict Story for more.